3.
Good evening, Cedar Falls. Welcome to the Standing Committee for Committee of the Whole for February the 5th, 2024. I'll call this meeting to order with a roll call from Madam Clerk.
Schultz.
Here.
Latta.
Here.
Cruz.
Here.
Hawbaker.
Here.
Ganfield.
Here.
Crispin.
Here.
Dunn.
Here.
Thank you. 2 agenda items tonight. First up, City Council training update.
Good evening. My name is Christine Stone. I'm an attorney with the Allers & Cooney Law Firm in Des Moines, and was asked to come and speak with you all this evening on some common topics that we receive questions on, and I know Kevin receives questions on these. So this is really just sort of big picture overview for elected officials, and some of the items that that you probably are involved with from time to time. So obviously the information I'm providing this evening is general in nature. Specific questions on specific situations should be addressed with your city attorney. But kind of the topics we're going to cover tonight are the big picture and the role of the city council, so how you all interact with each other and what your responsibilities are. We're going to talk about the open meetings law, and one of the subtopics that we will cover is ex parte communications, and then I'm going to talk briefly about the open records law. If anybody has questions along the way, feel free to jump in. I'm happy to take questions, although I know you have a busy evening, so we will keep things moving along. So under Iowa law and city code, that sort of outlines the lanes that you all operate within as city council members. So under Iowa Code Chapter 364, the state code provides a power of a city is vested in the city council except as otherwise provided by state law. It also says a city council shall exercise a power only by the passage of a motion, a resolution, an amendment, or an ordinance. And so therefore, you know, what we conclude from those statutes is that the Iowa Code does not vest power in any individual council member. The power that you have to do your job comes from your actions as part of the city council as a body. There are some unique exceptions for mayors. They do have some specific powers under Iowa law and city ordinance, but general council members do not. So for example, the mayor has emergency powers under city code. In times of natural disaster or emergency, the mayor can take some specific action. But as I said, city council members don't have individual authority. Another example is veto power. The mayor does have veto powers under Iowa Code Chapter 380, and then the emergency powers under 372. Cedar Falls, as a city, under your charter, you operate under the mayor-council form of government. So that allows the city to provide for a city manager and to prescribe the manager's duties and powers. And you have done this within your city code by ordinance, which is permitted by Iowa law. So your city code operates or establishes the framework under which you operate, and within the city code it dictates that the mayor is the chief executive officer of the city and the presiding officer of the council. And then within the city code, sort of the general framework is that the council sets policies and then the city administrator implements those policies. So you have sort of the big picture, oversight, policy setting duties, and then it's the city administrator's job to really implement those. Here's some specific language from the city code. It provides that the mayor shall supervise and evaluate the performance of the city administrator with input from the council, and the mayor shall give direction as necessary concerning the functions of city departments and may call for special reports from the city administrator at any time. And then the code also provides that the city council shall annually adopt broad goals, objectives, and program performance measures to guide the administrator in the development of the operating budget, capital improvement plan, and the administration of city projects and programs. So again, your job is to create sort of the big picture policy goals for the city, and then the administrator implements those. The city code provides the administrator is the chief administrative officer of the city, responsible to the mayor and council for the management of all city affairs placed in his charge by city ordinance. So just to summarize kind of the big picture of the city council, your authority and powers come from actions taken as part of the body, the city council, not your actions as an individual. You all are responsible for establishing policies and direction for the city, and the implementation of those policies is left to the city administrator with some direct supervision by the mayor. And this comes from both city and state law. Again, kind of, why it's important to remember sort of the authority piece and why you all should be conscious of that. If council members individually try to give direction or take action, there could be conflicting information that's being provided. There are mixed messages potentially, and it in fact can create some liability for yourself or the city, depending on what it is that an individual member might do. There's some case law out there that says if an officer acts in bad faith or if you knowingly exceed your authority, you can be held personally liable for that. So the general framework under Iowa law is that all actions that you take as council members on behalf of the city within the scope of your duties, you are indemnified for that. The city covers you for anything that you do within sort of those parameters. But if you were to go outside of that, if you're knowingly acting in a way that you're not authorized to do, those indemnifications may or may not kick in and you could be personally liable. So that's just something to keep in mind.
So just real quick, I don't want to sidetrack things. From a definition, during your explanation, you used city manager and city administrator. I've seen definitions that have some differentiation between the two. Is it the same thing, or?
So a city manager, generally there's a professional designation that goes along with that, but in my view, and I would say in common conversation, it's interchangeable. So a city administrator and a city manager are basically the same thing. It's just that professional designation.
Thank you.
Yes, you're welcome. Anybody else? Okay. We can move on to the open meetings topic. So open meetings is part of Iowa's sunshine laws. We have the open meeting statute, which is chapter 21, and then the open record statute, which is chapter 22. They are somewhat similar in that both of them have sort of policy statements at the beginning that explain the intent of the code. So in chapter 21, it says this chapter seeks to assure through a requirement of open meetings of governmental bodies that the basis and rationale of decisions, as well as those decisions themselves, are easily accessible to the people. And any ambiguity in the construction or application of the chapter should be resolved in favor of openness. So really, the intent of the open meetings law is for the people to understand why you're doing what you're doing. They may not always get a chance to, speak on that, but they get to know why it is you're doing what you're doing. And that's what the open meetings law provides. The law is to be liberally construed. Its purpose is to prohibit secret meetings and to require such meetings to be open and to allow the public to be present. So again, the public is entitled to know what you're doing and why you're doing it. So under the open meeting statute, there are definitions because, we have to figure out, okay, well, what is an open meeting? What does this even apply to? It applies to open meetings of governmental bodies. So what is a governmental body for purposes of the statute? It is clearly a city council, so anything that you do as the city council is subject to the open meetings law. And it is also includes advisory committees, task forces, or other bodies created by an executive order of a political subdivision of the state to develop and make recommendations on public policy issues. So some committees that are established can also be subject to the open meetings law. And then again, what is a meeting for purposes of the open meeting statute? It is a gathering in person or by electronic means, formal or informal, of a majority of the members of the body where there is deliberation or action upon any matter within the scope of your policy-making duties. So, buzzwords to call out there can be electronic So email chains sometimes, depending upon what's included, can be considered a meeting. They can be formal or informal, a majority of the members, and deliberation or action upon any matter within the scope of your policy-making duties. There is a carve-out. The code explicitly says meetings do not include a gathering of members for purely ministerial or social purposes when there is no discussion of policy and no intent to avoid the purposes of the chapter. So if you're at a ribbon cutting and, there are more than a quorum that are present, but you're not discussing city business, you're not taking any action, that is that would not be an open meeting. So if it is an open meeting, then the requirements of Chapter 21 come into play. One of the big ones is that the meeting has to be preceded by public notice. The meeting has to be held in open session unless closed session is expressly permitted by the law. All actions and discussions have to occur in open session, and each body is responsible for keeping minutes of all of its meetings. In terms of the agenda, you have to give notice of the time, date, and place of each meeting, tentatively what the agenda will cover. It has to be in a manner reasonably calculated to apprise the public of that information. It has to be posted on a bulletin board or other prominent place which is easily accessible to the public. Notice must be provided to the news media who have requested such information. And the notice, your agenda has to be posted at least 24 hours in advance of the start of the meeting, unless for good cause 24 hours is not possible or impractical. That should be extremely rare. Typically I would say the only time that should come into play is if there was some kind of a natural disaster or a flood or something happens and you have to call a meeting very quickly to take care of something that's really pressing and imminent. Then if you can demonstrate good cause why you couldn't have 24 hours notice, that's acceptable. But in 99% of the time, you should be able to post your notices. And even if it's less than 24 hours notice, as much notice as is reasonably possible is required to be given. So the minutes of your meetings must show the time, date, place, and members that were present at the meeting. It has to show the results of each vote. It has to include sufficient information to indicate the vote of each member. All votes have to occur in open session, and voting by secret ballot is therefore prohibited. So votes have to occur in open session, and they have to be documented. Closed sessions are permitted under Chapter 21. Right now, Section 21.5 lists 12 possible reasons for going into closed session. Nothing in the law, however, requires a closed session. You can always choose to remain in open session if you would like, although many times there may be good reason for going into closed session, and your city attorney may strongly recommend that you do so, depending upon what it is that you will be discussing. So I just urge caution with that. And then any final action that the city takes has to be taken in open session. To enter closed session, you can only do so by an affirmative vote of 2/3 of the member of the council or by all the members who are present at the meeting. Your reasons for holding a closed session have to be announced by referring to a specific exemption under 21.5 and has to be entered in the minutes. So people have to understand why it is you're going into closed session. The closed session discussion must be recorded and minutes have to be taken, and the recording and minutes have to be retained for at least a year. And obviously the purpose of that is if someone were to challenge the reason you went into closed session, that documentation would be what would be used to defend the city and show the court, if it's a legal challenge, that everything was done correctly. So just some sort of tips and reminders whenever you go into closed session. You should be very conscious of why you are in closed session. Your discussions should really be limited to that topic, the purpose of going into closed session. You shouldn't veer from that during the discussions. And if you're not sure if it relates to the closed session subject, you can ask, or when in doubt, just reserve your comments for the open portion of the meeting. Chapter 21 also covers some rules of conduct at public meetings. It provides that the public can use cameras or recording devices at open city council meetings. However, nothing in Chapter 21 prevents the city council from making and enforcing reasonable rules for the conduct of your meetings to assure that they, are orderly and free from interference or interruption. As a reminder, public comment is only required to be allowed at public hearings, but many communities choose to allow more public comment than that. But under the law, the only required public comment is at public hearings. Some other issues to keep in mind when we talk about open meetings are walking quorums or kind of serial meetings. So if a few of you are meeting and there's one person who ends up being in multiple meetings and you're all kind of talking about the same thing, that could be a violation of the open meeting law if you are all discussing policy-related issues and trying to figure out, who's going to vote what way, or do we have a majority, those kinds of things. So I would say be very, very cautious of that. You should really be reserving comment to open meetings. And again, the email chain that can turn into an inadvertent public meeting if you start talking about policy and decisions and things like that. So just be very cautious of that. And again, when in doubt, save your comments for an open meeting. Chapter 21 does identify the penalties for violations of the open meeting law. Damages can be assessed against all who participated in the unlawful meeting unless you can claim a valid defense. A valid defense is getting the advice of legal counsel on whether or not to go into closed session. So again, if you're not sure, you should ask. You should do that ahead of time. And the damages can be up to $2,500 in certain circumstances against each individual. So it's nothing to sneeze at. And then costs and reasonable attorney's fees can be paid by those who participated in the unlawful meeting, or if there was a valid defense, then the city would indemnify you and cover those. So just something to be aware of. Again, actions that are taken by the body in violation of the law could be voided as well. That's one of the remedies that the court could impose. And if it is a second violation of the open meetings law, the member shall be removed from office. And the court can impose an injunction against further violations of the law if someone prevails in the open meetings violation. Ignorance of the law is not a defense. So saying you didn't know or you weren't sure is not a defense. If you don't know or aren't sure, you need to ask. So kind of a subtopic within the open meetings law area is ex parte communications. So that is really something we're talking about due process rights when we discuss ex parte communications. So the Fifth Amendment to the Constitution states that no person shall be deprived of life, liberty, or property without due process of law. And the 14th Amendment also states that no state shall deprive a person of life, liberty, or property without due process of law. So this is also articulated in the Iowa Constitution, same language. And so due process really requires fundamental fairness in a judicial proceeding. So a trial that is fundamentally unfair violates the guarantees of due process in the U.S. and Iowa constitutions. And you may be thinking, well, we're not judges, this is not a trial. But in some circumstances, you are considered sort of an adjudicatory body, and so it's important to keep that in mind. The American adjudicatory system is generally premised upon the ideal that the search for the truth and the wise interpretation and development of the law are best advanced through an adversarial process in which each party submits evidence and argument while simultaneously testing the evidence presented and challenging the arguments made by the opposing side. So that's sort of our general premise on how judicial proceedings act in this country. So in the legal context, when a lawyer for one party communicates surreptitiously with a judge or juror in a manner that can influence the outcome of the adjudication, the other party has been deprived of due process or the right to be heard. And the confidence of the public and the impartiality of the tribunal may be compromised. As the Iowa Supreme Court has explained, the purpose behind the rule prohibiting ex parte communications is to prevent the effect or even the appearance of granting undue advantage to one party to the litigation. So where there is a dispute and you folks are serving as sort of the arbiter of that dispute, if you're having conversations with one side outside of the meeting context, you know, the other side is entitled to know that and they're entitled to respond to it. So it should be avoided. So again, these same principles apply to situations where a city commission or a board or a council is performing a quasi-judicial function. A quasi-judicial function is found where an activity involves proceedings in which notice and an opportunity to be heard are required, or where a determination of rights of parties is made, which requires the exercise of discretion in finding facts and applying the law thereto. So what does that mean? Quasi-judicial proceedings that you folks might be involved with are rezonings and other land use matters, variance requests, if they may come to you, and any and all appeals. So if it's a dangerous dog appeal, if that comes to the city council, or a liquor license appeal, if you have a process here that you hear those, you know, any and all appeals, those are quasi-judicial, and you should be very conscious about not speaking with parties outside of the public meeting context. At a minimum, due process requires that quasi-judicial proceedings involve notice, an opportunity to be heard, and an impartial decision maker. Again, those ex parte communications lead to one party being heard more than the other, and or can lead to an impartial decision maker. So you may, you know, have some preconceived ideas before you come before the actual appeal hearing, and that is a problem. Both of those would violate due process rights of the parties to the dispute. And so if you are, you know, not sure, or if there's an item that you know is going to be coming before you in the future, and one of the parties to that issue calls you, wants to have coffee with you, and you're like, oh gosh, I don't know if I should do this, you know, reach out to the city attorney, get some advice before you agree to meet with people individually, when you know they are going to be coming before you with issues down the road. So then moving to Iowa Code Chapter 22, the Open Records Statute. The purpose of the Open Records Act is to open the doors of government to public scrutiny and to prevent government from secreting its decision-making activities from the public on whose behalf its duty is to act. So again, very similar to the open meeting statute. The purpose of the chapter is so that the public can know what it is you're doing and why you're doing it. Public records under Chapter 22 is a very broad definition. It includes all records, documents, tape, other information stored or preserved in any medium of or belonging to the city, essentially, regardless of where they are stored. So, you know, if you send emails from your private email account and it relates to city business, those emails are now city records. Just because they might have come from your private account doesn't miraculously mean they're private. Does the information relate to city business? If it does, it's an open record.
Excuse me.
Yes.
How do we deal with emails that are sent to our private? Just not respond to them?
You can
when they
forward
have to
them to your city account if you have a city account. That would be one way to do it, or you can, you know, respond to it from your city account and say, please send future emails to this account, if you're really trying to limit the emails that come into that other inbox. But yeah, there's not a great way of people, if that's the email people know for you, they very well could be sending it there. So I would just say, you know, please send emails to this. If it relates to city business, please send them to this address.
And being that they sent it with the intent that it's city business, that becomes record, even though
yes.
maybe we don't respond to it or forward it, or?
So let's say a week later, somebody says, I want to see all emails to council member from X person, and X person sent an email to you, you would have to say, oh, I have one, even if it's in your private account.
Sure.
So that's the issue, is then managing that if it's coming into multiple places. So to the extent you can tell people to send things to your city email, I mean, that makes it a lot easier to manage. And I assume then the city IT folks would also have access and could help you search and things like that. So other practical reasons to try to do that.
Mrs. Stone, would you care to speak on the retention policy for those types of emails? The closed meetings, you have to keep recordings for a year.
Sure.
But in these emails, how long do we need to keep them?
So the law does not give a whole lot of guidance on retention. Cities are kind of up to adopt their own local retention policies if they would like. There are some documents, obviously, that cities have to keep forever, council meeting minutes, real estate records, bond records, things like that. But it is possible to adopt a retention policy citywide that says we're going to keep email communication for 2 years. The only trouble with that is then you have to actually implement the policy, and so then somebody needs to be responsible for deleting things that roll off the time period. So record retention policies are a good idea. You just have to be able to manage them.
Mr. Rogers, do we have a current retention policy?
Record retention, we generally go by the League of Cities recommendations, and for emails, I don't know that we have a specific number. I don't think for emails, so that means there is none.
Yeah.
So it's up to the individual council member how long they keep those.
Okay. Is it best practice that most towns typically have some sort of standard for that?
I would say the league's kind of guidance is what a lot of the bigger cities have adopted, with some tweaks. So sometimes if you don't have something specific to email, then you would just follow what's our correspondence, policy. But yeah, it kind of runs the gamut on that.
Thank you.
I keep my emails forever because I'm always terrified I'm going to need something someday. So I'm a bad example.
Which I wouldn't advocate for.
Yeah, no, that would not be a good retention policy. So again, what are public records? Public records can include things that maybe are even held outside of the city in some limited circumstances. So the code specifically provides a government body shall not prevent the examination or copying of a public record by contracting with a non-government body to perform any of its duties or functions. So our law firm, we are private. We don't, we're not employed by any particular city, but we do provide legal defense for cities. And litigation, and we provide, legal services for cities. So sometimes, in some limited circumstances, records that we might have that belong to the city could be considered public records, even though they're in our possession. We're attorneys, so there's a lot of confidentiality with what we do. But in some circumstances, if Kevin dropped off an abstract at our office for a real estate transaction, just because it's held in our office doesn't mean it's not a city abstract anymore. It's still yours and subject to the open records law. So examples of public records, it's all the typical things you would think of: contracts, handbooks, meeting agendas. Social media can be public records. Email correspondence, if it's non-confidential government business, would also be open records.
Mrs. Stone, real
Yes.
quick clarification on the social media aspect. In the instance Councilman Schultz brought up where a constituent emails someone, let's say it's an unknown email address for sake of argument, you're not aware of that record. Obviously there's little way you could go about getting that. Social media, someone reaches out an @tag that doesn't exist. What kind of responsibility do we have to maintain any of that correspondence on Facebook, for instance?
So again, social media policies are very good to have, where you might, sometimes your policy might be we're turning off comments, or we reserve the right to delete comments if they're, XYZ. But yeah, I would say if you have official city social media accounts, you should have policies on how long you're retaining the information that the city puts out there, as well as comments, if you do allow comments, just so that everybody kind of knows, what the rules are. Because what you want to be in the position of, if somebody a year from now says, well, I posted something on social media, they knew about it, I want an open records request for that to show it. If you have a policy that says, well, we delete comments after X number of days or months, to say why you don't have it, I mean, that's what you want to be in that position.
Does that apply equally to council members for their social media? If a constituent reaches out by a Facebook post, is that something they're required to retain?
So if you use your personal social media for city business, the open records law could come into play. So it really depends, but there's a lot of litigation across the country right now on those types of issues. So I would say, similar to having a city email and a private email, you may want to have a city social media account and a private social media account, where you can clearly delineate between the two so that they're not sort of overlapping. But yeah, that's something to be careful about.
Would you be able to clarify what would constitute a confidential email via city? Your slide previous.
Oh, non-confidential records?
What would constitute a confidential record?
So if city attorney sends an email updating you on pending litigation, for example, confidential
So
attorney-client
if it's confidential within the
privilege.
subject line, that's protected? Yes?
If the content is privileged and it's labeled privileged, it would be privileged. It really depends on content. So it's just because someone says confidential in their subject line doesn't 100% mean it's confidential.
For example, if I sent you an email, Chris, and said, hey, I'm having a 4th of July party, and I label it confidential, that's not confidential.
Noted.
Right. Yeah.
You heard it here first, folks.
I didn't get an invite for that.
Ministerial purposes only.
That's right.
Just lastly, to get you in the weeds, I'm sorry, but if a constituent reaches out to a personal social media account, does that constitute city business because they're asking about a civic matter on the agenda? Just because you have 2 accounts, that doesn't mean you
Right,
don't have to retain
regardless
that.
of, I mean, public records are public records regardless of where they are stored. So, yes, it's very easy that someone could send something to the wrong account and now all of a sudden, oh, it is, a public record. So just be careful about that. Under the open records law, the examination and copying of public records shall be done under the supervision of the lawful custodian of the records or the custodian's authorized designee. The lawful custodian cannot require the physical presence of a person requesting or receiving a copy of a public record and shall fulfill requests for a copy of a public record received in writing by phone or by electronic means. So essentially what this means is that if folks are asking for public records, you have a duty to respond to that. It doesn't matter how the request comes in, who it comes to. If someone in the city receives that request, it's an open records request and you have a duty to respond to it. You could have policies in place that say, we want open records requests to get funneled to the city clerk and we want them to come in on this particular format, and you can do your best to inform the public about that. But if someone chooses to ignore that and sends a request a different way, you still have an obligation to respond to it. So who is the lawful custodian? It is the governmental body currently in possession of the public record, or the body owning a record when in the physical possession of persons outside of a governmental body. So again, sort of that abstract example. It's still a city abstract, even if it's sitting in our offices in Des Moines. And each government body shall delegate to particular officials or employees of the governmental body the responsibility for implementing the requirements of the open records law. So you should have delegated that responsibility to someone. Again, requests can come in verbally, they can be in writing. You can require the use of a specific form, or you can strongly encourage people to use a specific form, but if they don't do it, you still have to respond to them, and magic words are not required. So fees is a big topic that is the subject of many disputes that we see in our office. So under Iowa law, a governmental body is able to charge for the reasonable expenses of providing open records in response to open records requests. The law was changed recently to say that any request that takes less than 30 minutes to produce, you should provide that free of charge. But if it's going to take more than 30 minutes to produce the record, then you are entitled to charge reasonable fees. You do have to communicate the fees to the requester in advance, preferably. So if a big request comes in, you know it's going to take a lot of time to track the documents down, review them, produce them. Best practice would be to get back to that requester and say, hey, here's our estimated fee to provide the documents to you. Do you still want us to provide them? Do you want to narrow your request? That type of thing. A person can contest the reasonableness of the custodian's expenses. So you always want to keep that in mind. The fees that you charge cannot exceed the actual cost of providing the service. And again, reasonable is all throughout the chapter. So some communities have adopted open records policy where they have just like a flat fee that they charge per hour for the requests that come in. Some communities charge the actual rate of whoever is doing the work. Some communities charge the actual rate at a 50% discount. You know, it's kind of what you think is reasonable, but the code says reasonable cannot exceed the actual cost. And we do have many clients who charge the actual cost of what it takes to provide the records, and under the current law, we believe that is appropriate. Costs for legal services can only be utilized for the redaction or review of legally protected confidential information. So if you do have a request and you're not sure what's confidential or not, you can have an attorney review it and you can charge those legal fees if it's just to review the confidentiality of the documents. The code does allow the city to adopt reasonable rules regarding the examination and copying of records, and you are required to post information for making such requests in a manner reasonably calculated to apprise the public of that information. There is no strict deadline within the code about how quickly you have to produce records when they are requested. But an extensive delay can be considered a silent refusal, so you do want to be timely. There is a provision under 22.8 that says a good faith reasonable delay by a custodian in permitting the examination and copying of a governmental record is not a violation of the law if the custodian is going to court to seek an injunction to protect the documents. If you are still reviewing the records to determine whether a confidential record should be provided or not, and a reasonable delay in these circumstances shall not exceed 20 calendar days and ordinarily should not exceed 10 business days. But really, best practice is produce the documents as soon as you reasonably can, is really what the law says. There are a number of confidentiality provisions under Iowa Code Chapter 22. Currently, there are more than 70 categories of confidential records. And similar to the open meeting statute, you can always choose to release records that are otherwise confidential under Chapter 22. But again, there may be very good reason not to do that, so you should seek legal guidance before you make that kind of a decision. And so some examples of what is listed as confidential records would be attorney work product, peace officers' investigative reports. However, there is an exception for the immediate time, facts, and circumstances surrounding a crime, and that exception has been broadened over the last few years. Personnel records of employees are considered confidential, but again, there are exceptions, you know, an employee's rate of pay, how long they've been at the city, those types of things are not confidential. Library records under Iowa law, folks are entitled to privacy regarding what they are checking out from their library, so those records are confidential.
Quick question. I mean, on the, back up a slide there, the personnel records, their application to be on a board or commission, that would be public because it's in our packets, so we can retrieve that?
Yes, particularly if they come in your council packets, yes, then they would be open records at that point.
Okay.
I would say employee job applications under the current status of the law, those are confidential, but board and commission appointments, I would say those probably are not.
Thank you.
Under case law, the Open Records Act does not affect other specific statutory privileges recognized by the legislature, such as the attorney-client privilege. So essentially what the case law says is that 22.7 is not all-inclusive. There are other exceptions. Attorney-client privilege, utility records is found in Chapter 388. HIPAA obviously is under federal law. So just because it's not covered in 22.7 doesn't mean, it doesn't still apply. So some of the issues that we see with open records that get difficult are broad requests. It seems like, nowadays a lot of communities receive these very broad requests. I want every email between every council member and person X from the beginning of time to today. And so those can be very voluminous and difficult to respond to. And that makes, collecting the responsive records difficult because, again, if they're coming to your private email account somewhere outside of the city still has a duty to check on that and collect that. So collecting responsive records can be difficult. One easy way to avoid problems with open records issues is to at least acknowledge receipt of the request. We've received your request. I forwarded it to whoever department head to review. We will provide you with a proposed fee, within the next week or two. If you haven't heard back, please feel free to follow up or something. Many times just communicating with people can help to, and giving them a time frame can help to avoid, potential problems down the road. And then fees. We continue to see a lot of complaints and litigation brought over fees. So again, you always want to be reasonable, never exceed the actual cost of responding to of providing the documents, but you are entitled to charge fees. Similar to the open meeting statute, open records violations can be punishable by an injunction. There can be assessment of damages. Attorney fees, again, are available, so this is why we see litigation in this area. And again, you can be removed from office if there was a prior violation. So those were all my prepared comments. I'm happy to take questions if there are any, or you can feel free.
I just have one quick one.
Yes.
Going back to the required components of minutes, I think it was slide 22 maybe. Any sort of discussion, debate doesn't have to be in the minutes, right? It's just the actual motion and the vote? Or do you see tidbits of the discussion, or what's?
I would say different communities handle that differently. From legally speaking, you have to have an agenda that says what you're going to discuss, and then you have to have minutes that show who was at the meeting and how the votes went at the meeting. Detail beyond that varies dramatically from community to community. If you record your meetings, then I would say you could probably get by with very brief minutes because you have a recording to back it up.
But what was in your slide, it didn't have anything to say about discussion.
Yeah.
So that's kind of, I was curious.
Yeah. The vote is really what's important and what the code specifies. So beyond that, I'd say it's kind of local practice.
I mean, you got the topic on the agenda. So
right. So people know, if they wanted to know, they could have come to the meeting.
Or
That's
listen to
kind
the
of the
recording.
response. Yeah. All right. Well, I know you have a busy night, so I won't take up any more of your time, but thank you.
Thank you.
Thank you.
Thank you very much. Next up on the agenda, Hearst project update.
We have a number of people that were waiting out in the lobby, so they will come here. Give Linda. There you go. Yeah.
what her definition of adopt and receive and file is.
Mr. Chance.
Just a moment while my entourage gets settled.
No problem.
Hey, no, it's not dead, it's not, I know, it's not dead yet.
Just want to give a shout out and thank you to how many staff and the board that you have,
Yes,
commission members, I should say.
that's coming. Good evening, you all. Thank you for giving us the opportunity to talk tonight. Just a quick introduction, since there are some new members on council. My name is Corey Hurlis. I'm the Cultural Program Supervisor here at the City of Cedar Falls, and the majority of my role entails the day-to-day operations of the Hearst Center for the Arts. And let me introduce my co-presenter.
Hi, my name is Heather Linksweiler. I'm with OPN Architects. I worked with these great people to get the study put together that we're going to show you today.
And so here's to all my many thank yous to the great support we have from the community, and in particular, the folks that came here to support us tonight. And again, just for your familiarization of some of the participants, we have several in the audience of the Friends of the Hearst Board. They are the 501c3 nonprofit arm of the Hearst Center for the Arts. They've been operating and helping the organization for over 35 years, handling memberships and fundraising for all sorts of things to keep us in operation. And then the Cedar Falls Art and Culture Board, also many members present at this meeting. Thank you so much. And the city's staff, and including the Hearst staff, who have come in great support. I really appreciate them taking the time to come here as well. And then additional thanks, or I will miss it. I also want to thank all of the public who came out to the community public open house that took place on October 24th and gave us their comments and feedback. Much appreciated. And then just to briefly tell you about how we got to where we are here tonight. This current project really started back in 2018 when there was a building visioning committee that was convened to examine space deficits in the Hearst. The building, as of 2024 in May, will have its 35-year anniversary. And so what started out as a 1940s house owned by James and Merrill Hearst was then, once it was bequeathed to the city, was added on to the structure that you still see today. So a lot of the original infrastructure still exists just as it did in 1989. And over that time, there has been an evolution in the type of communities, the number of community members that we serve, the type of workflow, the type of programming that we do has changed over that time. So there have been a lot of pain points in our operations, and that's partly what the Building Visioning Committee was kind of looking at, is what kind of programming were we doing now, and what do we want to do in the future, and how does the building layout inhibit or help that? And so after that Building Visioning Committee convened, they wanted to do the next step. So we listed the anticipated maintenance needs of the aging facility. So all the plumbing, elevator, roof, HVAC systems, all those things that are approaching 35 years and kind of aging out, a list of those was made. And then COVID happened, which, it derailed a lot of us, including this project. But one positive thing that came out of what we went through was that there were discussions at the time of possibly moving locations. Maybe downtown would be a better fit, but the pandemic definitely demonstrated to the neighborhood and the community and people who wanted to come visit us and take advantage of programs that the current site that we live in is really ideal and great for what we envision moving forward with the Hearst Center. James and Merrill Hearst were all about nature. That's what James wrote about and what he loved. And the site now has grown, has great mature trees, has a beautiful sculpture garden adjacent to a bike path, really close to UNI. and all of the outdoor concerts and the things that we were putting together during that particular time. We've continued those today, and we get a lot of support for those. So it was decided to keep the Hearst at the current site that it is. And so 2022, that was the last time that staff here came and presented to council about the Hearst and their desire to move forward with getting a contract and getting a master plan to figure out what the next step forward, what the building should look like, what the layout should look like. And so they went through that process of hiring OPN architects, and the contract was approved on February 8, 2023. And so now a year later, the project is reaching its end, and so we're presenting to you the findings of that report and hoping to move the next step forward. I'm going to have Heather talk a little bit about what a master plan is.
Thank you. That was a really good description. You actually took some of my stuff, so we'll see if we can get through that. So we were tasked with looking at the difference between a new and a renovated option for this site. So it was pre-assumed, like you said, that the site was going to be the site. We were not going to look at a different location. It was also pre-assumed that the red house that was on the property adjacent to the Hearst Center was to be demoed as need for this project. So when we started looking, we're looking at new and old and evaluating the building, seeing what we could save, what makes sense to save, what makes sense not to save in the evaluation of a renovation. Now, as we worked through the project and we were confirming the program needs, as we looked at the topography and the nature of the needs, it made sense that the new building that would be priced and the renovation building that would be priced would be the same footprint. So you've got a real apples to apples when you're looking at the cost differential between the renovation and the new. We had solved a lot of the adjacency issues and the size needs for now and into the 30 year. So we felt comfortable with that being a solution. The next part that we do.
And I will add, as far as master plans go, just from my previous experience with master plans, it tends to be a working document. It's not finalized design documents. So what Heather has done is creating a design based on feedback of a good formula of what to follow to get us where we need to go. But they're not finalized design documents. There's a lot of steps to go, but this creates a roadmap and a good guide to get us where we need to be.
Yes, thank you. So one of the first things we did is we went and we looked at the site and the condition of the building. You hit all of the good points about why the site made sense to stay there. And the items that were the beloved items were also things that were landlocking the project. We didn't want to tear out the sculpture garden. We didn't want to impact any of the large trees. We've got a frontage that's sort of controlled where it is today because it's similar in alignment with the neighborhood. The parking lot was pretty much where the parking lot was going to be. And when you take the topography into account, it really kind of set everything where it needed it to be. But there were issues with accessibility, and that was one of our number one aspects to look at and correct. Now, as was stated, the original part of the building was a residence. So it's built like a residence. It has floor-to-floor heights like a residence. And then the addition was put on, but then they had to stick with the proportions that the existing house had. Now, if we were ever to build a new facility, we would never have a floor-to-floor that's as low as it is today. There would be a lot of infrastructure that we would change, even just to update it to the needs of now. We knew that when we were evaluating the new versus old, or new versus renovation, the renovation was going to be the hard one. We know that if we tear everything down that we can build, and so that was good. So we spent most of the time evaluating what we could keep and what didn't make sense to keep. The outside of the previous addition is brick, And it needs some tuck pointing, but it's in good condition. So that was something that felt like if we tear that off just to put something back, that didn't really make sense. So let's keep that. The foundations, like I said, the footprint made sense. We can extend it, so that worked as well. So we looked at keeping the foundation, the main foundation, and then adding a foundation as need to make that extension. This is where that floor-to-floor becomes an issue because we hold that in a renovation. In a new building, we would change that elevation. Let's see. Sure.
And then the final thing I'll add, just for council's awareness, if you've never noticed the property that's next door to the Hearst, it's at 224 West Searly Boulevard. We call it the Red House Studios. So that is a property that the city acquired a while back, and now it serves as our artists in residence program. It's currently cut up into 4 different artist studios.
So the next evaluation we did was the inside, and like I said, it's a residence, so it has hallways, small corridors. You have the old kitchen that's been converted into a small little nook for dining, and the offices were bedrooms. So they've been doing the best that they could with the layout that was there. The new addition provided an open area for the gallery, an open area for the recital hall, and a stage. Those are both items that were very important to keep, not necessarily exactly the way that it is, but that they were elements of the program that were important to have and to increase their size because of how popular they are. The bathrooms need to be updated. I already spoke about the accessibility of the building. It is not accessible to the standards that we would expect today in construction. The stage is not accessible, so that is an issue as well. And then your permanent art storage is in all the little cubby holes throughout the building. It is not in one location. And it is, we've got water pipes that are running through where you would not want water to be. So those are some of the big items that we were contending with and in seeing how we could renovate and make it worth the money putting in there.
And some of the other programmatic issues that were inhibited by the current way that the building is laid out is, for example, the performance hall. Often our plays, for example, the Red Herring plays often fill up, and people are sent away. And then if you want to have refreshments, then you have to take them through an art gallery with artwork on the walls that could be on loan from other institutions, and we can't have food or drink in the galleries, so then that becomes a workflow issue. Or the ceramic studio is now, it's one of our highest demand offerings, and we can only have 3 people on the wheel class at one time. So, and then there's just no room to expand or create another space for firing ceramics and drawing and all the steps needed for some of the more intensive art mediums. So those are just a few of the programmatic issues. Besides, staff are also hidden away in little cubby holes, and for collaboration, not ideal.
So what you see in front of you now is the proposed footprint of a renovated building. The green location indicates a front entryway. It's larger than just a vestibule, but this allows for flexibility. We worked with the different groups to discuss adjacencies, flexibility, needs, ways that you could increase your revenue for the use, and that was the performance hall. That made the most sense. And like Corey was talking, right now, the whole building has to be open in order to get to that performance hall. Whereas if we pull it to the side, and then we have it right next to that entryway, it allows us to close off the museum portion, protect that artwork, but yet still have the functionality of a evening event happening in that space. It also the green space can also be for local artists, small gallery showing. The whole point of that was flexibility. So that's the flex space, because we don't want to produce, or we don't want to create a space that only gets used for one function if we can avoid it. Bathrooms, one function, that's all you get. But the green can flex back and forth. So you see the light blue, that's the gallery space. So it stays nice and open. And part of that, again, was flexibility, because you can ebb and flow with the different sizes of gallery showings, but it also allows the staff to be able to see all of the area that the public is in. So it helps create a more safe, secure, and high-functioning building. The yellow color that you see that represents where the staff is, that is where the auditorium or the performance area is today. We really just took that space and put some offices in there, allowed them to have an open space in the middle, which instead of corridors, we have that open space. They can do collaboration. Right now, they're all over the place, and they don't have one area that they can meet as a group to brainstorm ideas for fundraising. And then if we go downstairs, the lower level, you've got the darker blue, and that is going to be the educational program space. So there's 2 additional in that area, and then off to the left, we represent another blue, and that is then the ceramics lab. And we put that on the edge so that we can put firing and exhausting and mechanical that we need in order to coordinate with that piece. Now, if you recall, the existing building is we'll call it split level. On the lower level, you can walk outside. That means that part of the building is buried. And that is not where we want to put people space, because there is no access to light, natural light, and it's just not a healthy place to be. But it is perfect for storage of artwork. Artwork does not want sun. Artwork wants humidity control, and so that worked to our benefit and one of the reasons why that L shape still made sense to maintain.
And in your packets, you'll see a lot of these layouts, and that just kind of demonstrates all of the work that Heather and staff put into talking with our Friends Board and our ACB Board and with the public and further refining those ideas. So what you see as our preferred concept, this is probably the 5th or 6th version. So there's been a lot of really good positive feedback that have really helped refine the concept and make it as good as it can be. And the only other part on that diagram that I'll point out is the purple for flex ed or artist space. That could manifest as many different functions over the decades, but that is kind of bringing the artist residency program from the Red House over to the main area of the Hearst Center. And you see one of them is located close to the ceramic studio, so to give a lot of flexibility for artists who might want to have a residency that is adjacent to ceramics, or another one located closer to where their other art classes are happening with 2D mediums like painting.
The next image that you'll see, this is the existing footprint of the facility. The dashed that you see is the proposed extension. So it's really focused on 2 locations with some facade work. One of the things that we noticed when we first approached the building for the first time is that we thought we were going to a dentist's office. It does not give you the sense that you're about to enter into a gallery. And I was blown away with the gallery on the inside, and I was just going to drive right by. So increasing the street presence. And instead of trying to just change the windows or some of the patterning, we went ahead and we're proposing that we would pull the front facade out, which would allow us to be able to change the character that's there today. And then off to the side, that would be the performance hall, auditorium. And then the dash on the sort of that leg that goes up really represents the footprint that the additional classrooms would use below. And that allowed us then to build out the space large enough for the staff. If you look there, the gallery itself did not increase in size too terribly much, but the education space, you will see that is a significant increase because that was the demand and the need from the community that was found. So.
Well, and I say that the new expanded lobby that you have designed really does open up other possibilities as well. I can see a scenario where our curator is able to use that main gallery for forming thematic exhibits and box shows, but that really large lobby space will be a gem for doing the other aspect of an art center, which is highlighting local art. So having local art on display, having pop-up workshops for teaching different art mediums from these local artists, for featuring our artists in residency. So I view it as a lot more gallery space for sure.
So as we worked through the interior, now again, this isn't a final design, but we needed to push the concept far enough that we knew what we were pricing. And so to understand how you might use the space inside. You've got the upper corner render of the proposed exterior. You see how it cleans up the facade, it brings it forward, and it gives opportunity for signage on the building, but not have it be grocery store signage, but yet something that's more subtle and more along the lines that you see on different art galleries. One of the next image that you see is that we're proposing to cut a central stair in the middle and have natural light come over this. What this does is it makes the lower level not feel like a basement because it has that connection to above, which just makes for a nicer space to be in. And today, if you try to find the stairs, they're off in the corner and the elevator's off to the corner. And this is about circulating through the space, using the space, seeing the art. And so to bring that to the core really made a lot of sense for the functionality. The next image you see is the proposed auditorium space. It really is very simple. It can be rearranged so that you could have a different wall that you're presenting on depending on how somebody wants to engage in that space. We have the opportunity for natural light that's there today, or that they have today, which was important to have that connection to the outside, but then also be able to have blinds. One of the other benefits to having it in this location is that we can put a storage space right next to it, because today they don't have the ability to put extra chairs or the equipment that they need. And I would say that your IT is a little antiquated. And then the larger picture that you see there is the flexibility space. So that's that entry space. As you come in, you could have soft seating. You could have a group of painters come in and do afternoon painting. It can change with whatever the function and the need needs to be.
And I particularly love the front facade from the outside. I can just imagine it where right now when you walk by the dentist's office facade, which was what I thought it was too when I first came here, the windows only look into just the front lobby area and then some offices, including my office. But here, with pushing that programming to the front, when you drive by, you'll be able to see more dynamic things happening from day to night. You can see from those vertical windows on the left side, you'll be able to see some performance going on. From the other side, you'll see that, and the windows on the other side, might be able to see some of the local art or the pop-up activities we have going on, things that you can see from the road that draw you in.
And we do have additional images that are in the appendix that you received, so those are larger. I think with the description, you probably can figure out which picture goes with which. So the next one. Now this was really important when we did our open house, because it's how does this building, if it's going to increase to 20,000 square feet, how does that still feel friendly to a neighborhood? And it was very important to be able to do that. The top image you see is the existing building with the peak roof that's in the back addition, and it shows that dash line is the area that we are proposing that the building would be. So it visually doesn't take up more height, and it does not feel odd from where it was before. And we've extended out that face. So it really does not change the connection it has to the neighborhood, But it does give the opportunity to make it feel like it is not a house, that it is a community space. And then here you'll start to see these images that represent the addition and renovation, not the new. So the front facade we talked about with the windows being able to see the activity inside. On the west elevation, we really kept what's there today. That's the parking lot. We don't need additional windows into the gallery space, so we could use that. The southeast side shows that bump out that would create the 2 additional program spaces or classroom spaces with then up above it is the staff area. And then as you go to the east elevation, this is where the topography really starts to show itself. And in order to maximize access to that back, we would be proposing that there's a stair on this side, but then on the side with the parking, there can be a ramp that would get you there too. So you have multiple ways to access that area in the back. The white box that you see right there, that is the wall that is adjacent to the proposed storage. But the thought is that maybe that can be where you present evening presentations, whether it is an art exhibit or if it's just movie night with the family. It gives life into the evening for that plaza area.
And for me, from a programming standpoint, I told Heather early on, just in I was rather new here, but the fact that the site was so beloved and the beautiful sculpture garden and how great people just enjoyed relaxing, walking through the areas and enjoying the outdoor programming, I really tasked Heather with kind of leaning into that. And so what I really am excited about is, like you can see in the southeast elevation concept, that patio is going to invite classes out. So bringing nature to classes, you could, where some of those windows are, where the ceramics lab would be. So you could kind of bring them out easily. And so it kind of really leans into what we've been passionate about for years, but also James Hurst. Mm-hmm. And our open plan, or our master plan open house, just wanted to bring out that thank you to everybody that came in attendance. We had 53 and 26 people submitted written comments. Overall, the in-person comments were overall very positive. Loved the fact that we were staying in the neighborhood. Even people whose houses border us, that I might have expected some pushback about noise or anything else, they were happy that we were staying here, and the majority of the comments were that they liked the functional flow. It all made sense. An expansion instead of a total remodel seemed to make sense for them. And it was just only nitpicky things like, what are we going to do with James Hurst fireplace? Just those little type of questions. And so to the brass tacks. So we did all this cool stuff, and you got this really cool building, so how much is it? OPN, in your packet, you'll find a very itemized listing of the pricing, and this is for the addition and renovation concept. This is not for bulldozing everything and starting with a new building. So everything that Heather has presented, that layout, we're looking at a price tag of around $6,930,000. She did a great job of breaking down into percentages what that budget entails. She did go ahead and give us a second pricing option if we wanted to do the same type of concept, but with a completely new building and starting over fresh with $9.1 million. And maybe you can talk about how you got to those prices.
Sure. So in your packet, you'll see that there was an itemized list of what the costs would be. This is the way that we build kind of that total. We work with a third-party vendor that is our estimator. They are better at estimating, we're better at designing. So we keep it separate. We provided them all of the images, the floor plans, the elevations, the size, and a description of what the materials would be, could be. All of the materials and items that we said that they should put in here for pricing is middle of the road. Nothing's extravagant, and nothing is bottom because we know we can always make something cheaper. But it was very important that the longevity of the building and the fact that this is a public building and you want 30 years out of it, it really requires you to use certain materials. And that's how you're going to get your long-term, sort of the maintenance not being as high. You know, we could put less priced items, but you're going to replace it in 10 years versus others that would last.
And construction costs always are going up, so how long would this price?
So what we did is we had them escalate the cost to 2025. Now, these are all just kind of the best guess of what the prices could do. So the longer that it takes to fundraise or push to go, the higher the building's going to cost, just with inflation nature of it.
And so the next step, what happens after this? Well, this beautiful master plan, we'd like to move forward with after this, getting a consultant to do a fundraising feasibility study. We know about how much we want to do, how much that costs. Do we have the community resources to cover it, or do we have to change our game plan? So that fundraising feasibility study and then the resulting fundraising capital campaign estimate FY #24 to '26, and then our anticipated design and construction FY '26 to '28. So thanks for coming along the ride with us. Do you all have any questions?
Thank you. Open it up for questions.
I have one to get us started. So, what are you going to do with the James Hurst fireplace?
How much do you want to bid on it?
Oh, are you saying you want it?
I think Daryl's going to get on it.
So is this a fundraising opportunity?
So just to compare first off on parking. So in your design, you feel we have enough parking right now?
It depends on the everyday, yes. On the special occasion, when there is a large performance or gathering, there would be additional needed. We were able to add a few more parking spaces because we will be retopping it. And then there's some trees that aren't healthy and need to go, so that we gain a little bit that way. Discussing with city and how the street parking is, there is a potential of providing additional parking on street. That has to be all gone through, but that was tagged as an opportunity to gain some. And there was a nice neighbor that actually came that owned a large property piece that doesn't mind as long as everybody follows the directions on how to park. So that could be overflow. It really is, if we looked at putting additional parking pads somewhere else, the topography made it absolutely unreasonable in the price because we'd have to backfill a lot of dirt in order to make that flat.
And this isn't either new or this renovation project does not touch the red home?
No, both of them do. That's the
It
space
does. Okay.
that will be needed in order to increase that footprint.
Okay. And with your plan, if you would do the 9 million, that's like wiping out the parking lot, wiping out both buildings?
Yeah, the parking
So
lot would
demo
be
would be-
replaced anyway. So what we're really looking at is replacing the foundation, the slab, constructing the building in not wood frame, and having it be something that's more appropriate for a facility like this, being able to maximize the floor to ceiling height and getting the plumbing out of the storage area. We can bring the utilities and have a little bit more control over that. We're also, with this, we are keeping the roof of the most recent addition. That would stay, but the roof of the house would be demoed. But the structure would stay. So the roof, the roofing material, the plywood, all of that, but we would keep as much structure as possible. So if it was a new building, we would replace all that wood framing. We would have better floor to floor. The transition between the space would be a little bit easier. And we are living with a few items in the lower level that aren't fabulous, but they're workable. So we chose not to look at demoing them.
Thank you.
Other questions?
Will both of the full replacement or renovation be considered in the fundraising study, or is it just going to look at your preferred option of renovation?
The fundraising feasibility study, yeah, I think it would look at both options, and definitely if we couldn't do the 6.9 million, then we don't have to look
Right.
at the new building. Yeah.
Is there any longevity difference from the new build versus the remodel that we should be taking into account for the long term?
Yeah, the wood framing is not ideal for the long term. And the weight capacity of the floor, as we keep that and keep some of the structure, it could limit some of the art pieces that come in. If you want to start doing three-dimensional, larger pieces of art, they would not be able to sit on the floor. So you could live with it, yes, but you'll always have that kind of little bit of you lived with it.
Yep. Thank you.
And I'm sure there's still some or layout tweaks you could do if we were completely demoing it.
Yeah. I would say the bathrooms and the hallway aren't the greatest, but that's one of those you live with it.
To clarify, if I'm reading your bid correctly, the 10% increase is just taking into account cost if this was in 2025, is that right?
Escalation.
So present day it's 6.3 and then,
Right.
thank you.
So that one's always a hard one, because when we were doing this study, lumber was about 5 times the amount that it was prior. And so it really kind of played with us a little bit. And so we tried to take the middle ground at the point. So the escalation here is maybe a touch higher than it would be if we were to do this estimation now. But for what you're doing and the fundraising aspect, I think it gives you a strong basis to know where those numbers should be.
Thank you.
As far as the floor plan, if we did a total replacement, I was looking at the kiln being right next to art storage. Is there a buffering insulated wall there?
Yes.
And is there a different floor plan if it's totally replacement, or is it similar fashion?
I think that, if it's a go and say, all right, we're ready, the first thing we would do is we'd reevaluate the plan, depending on what scenario gets chosen, especially if it's a new. And if some of the, like I said, the hallway is not the best, it's narrower than what you'd want for a children's space and education. It's about 3 feet narrower than you'd put in a school. The bathrooms would be a little oddly placed, but they would be accessible. So yes, those are the things that we would correct.
Mrs. Hurls, any concern from the noise on the backside with the patio? There's some noise in that area, kind of a high-pitched whine from the neighbor. Is that a problem for that area at all?
Those neighbors did come, and so I did inquire, and nobody has given me a riot act about playing too. Of course, we don't play over, 10:30 or whatever the limit is.
Not your noise. I'm wondering if you can enjoy the patio
Oh.
quietly.
Yeah, we do. Currently, we do, yes.
Other questions? Okay. Thank you very much.
Thank you.
Nice job. Thank you.
Thank you. That concludes our agenda for tonight. Do I need a motion to adjourn? Motion to adjourn? Anyone? No? Okay. Well, hey, it's 6:35, 6:38. We're going to have our council meeting at 7. Feel free to hang out until then. We are adjourned. Thank you.